5 seconds to go. Start. In a life insurance corporation, this court reiterated that the freedom of speech and expression under Article 19(1)(a) must be understood to take within its ambit the freedom to circulate one's view, that such circulation could be by word of mouth, in writing or through audio-visual media, the freedom to air one's view was declared as a lifeline of any democratic institution, and the court expressed strong criticism at any attempt aimed at stifling or suffocating the right to circulation. In the said case, the appeals concerned separate instances of state-controlled entities (LIC and Doordarshan) refusing to publish or broadcast work that criticized the government. The court reasoned that government-controlled means of publication have a greater burden to recognize an individual's right to defend themselves, and if a state censors content, then it is obligated to provide reasons valid in law. That when a state-controlled entity refuses to circulate through its magazine or other platform, one's views, including one's defense, the right to circulate is violated. This court has therefore, on several occasions recognized the right to circulation, as a facet of the right to freedom of speech. The right to circulation includes, the right to optimize/maximize the volume of such circulation and also determine the content and reach thereof. Article 19(1)(a) serves as a vehicle through which dissent can be expressed. The right to dissent, disagree and adopt varying and individualistic points of view inheres in every citizen of this country. In fact, the right to dissent is the essence of a vibrant democracy, for it is only when there is dissent that different ideas would emerge which may be of help or assist the government to improve or innovate upon its policies so that its governance would have a positive effect on the people of the country, which would ultimately lead to stability, peace and development, which are concomitants of good governance. The following judgments of this court on the right to dissent are noteworthy. In Ramesh Thapad, this court recognized that criticism or dissent directed against the government, was not to be curtailed, and any attempt to do so could not be justified as a reasonable restriction under Article 19(2) of the Constitution. This declaration by this court cemented the idea that the freedom of speech and expression covers the right to dissent or criticize, even when such right is employed with respect to criticism of governmental policy or action or inaction. It is now recognized that the right to dissent is an essential prerequisite of a healthy democracy and a facet of free speech. In Kedar Nath Singh versus State of Bihar, AIR 1962 SC 955, this court considered a challenge to sections 124A and 505 of the IPC, which criminalized attempts targeted at exciting disaffection towards the government, by words, or through writing and publications which may disturb public tranquility. Although this court dismissed the challenge to the virus of the aforestated provisions, it was clarified that criticism of measures adopted by the government, would be within the limits of, and consistent with the freedom of speech and expression. Subsequently, in Directorate General of Doordarshan, this court observed that the state cannot prevent open discussion, even when such discussion was highly critical of governmental policy. The right of an individual to hold unpopular or unconventional views was once again upheld in Khushbu, wherein this court quashed first information reports (FIRs) registered pertaining to offences under sections 292, 499, 500, 504, 505, 509 of the IPC, based on complaints regarding the unpopular comments made by the appellant. Stop.